The case study we chose will dive into the legal differences between sales agreements and leases. Before we dive into the case itself, here's a little bit more information about sales agreements and leases. Sales agreements, according to the UCC under Article 2, is a contract where the seller transfers the title of goods to the buyer for a price. Conditional sales agreements are a financing arrangement where a buyer takes possession of goods, but the seller retains title and the right to repossess until the full purchase price is made. Full ownership of power or transfer of title occurs when the buyer completes all conditions of the sales agreement, typically full payment. Lease agreements, according to Article 2A of the UCC, are the transfer of the right to possession and use of goods for a set term in return for consideration. The result is not a sale or creation of a security interest, thus there is no transfer of title in this agreement.
This case involves a leasing issue between well-known agricultural company John Deere and the Power Brothers. The Power Brothers were looking for a company that would help them out by renting them farm equipment. They signed two lease agreements with John Deere to use a combine and a platform. These agreements were supposed to last for 5 years. The, the Power Brothers agreed to pay John Deere monthly payments called rent payments for the use of the equipment. At the end of their lease term, the Power Brothers would have the option to buy the equipment that they had been renting. However, a big problem occurred that caused a lot of issues. In February 1984, the Power Brothers could not afford to pay their bills anymore. This led to them to file for bankruptcy under Chapter 11. The Powers did this in hopes of rebounding their finances while they continued to run their business. By March of 1984, John Deere was unhappy with the Power Brothers' situation. John Deere wanted the Power Brothers to make up their minds. They gave them two options: keep the lease agreement or cancel them. John Deere then filed a motion in hopes of forcing the Power Brothers to make up their minds.
The court is now in session. We're here today to determine whether the contracts between the Powers and John Deere leases are true leases or sales contracts. Mr. Deere, you may begin.
Thank you, Your Honor. The Power Brothers leased farming equipment from us. The pieces of equipment were combined into platforms. After a few months of the lease, they stopped making payments. Even though they filed for bankruptcy, they still either must reject or accept both the leases.
Your Honor, with all due respect, these weren't actually leases. They may appear like leases, but in truth, we were actually buying the equipment. Tommy and I took on all the risk, the maintenance, and even put a purchase option at the end.
Thank you for your input, Mr. Powers and Mr. Deere. Were the Power Brothers responsible for the upkeep?
Yes, but we still called it a lease.
Mr. Powers, you said you had an option to buy the equipment at the end. Is this true?
Yes, for a fixed price. We also made large payments up front, just like a loan.
I see. After reviewing all of the given facts, this court finds that these so-called leases are in substance conditional sales agreements. Just because they were initially labeled at leases does not constitute them to be a lease.
But Your Honor,
With that being said, I am still granting your motion. Mr. Powers, you must formally assume or reject the agreements by September 24th, 1984. If you do nothing, the contracts will be deemed rejected and John Deere will be entitled to repossess the equipment. That it all.
Understood, Your Honor.
Court adjourned.
The court determined 5 factors that are relevant in considering whether a lease is a true lease or a security agreement. These are the total amount of rent under the lease, whether the lease acquires any equity in the leased property, the useful life of the leased goods, the nature of the lessor's business, the payment of taxes, insurance, and other charges which are normally imposed on business. These factors, according to the courts, are important for business persons to apply when trying to understand the classification of a sale, conditional sale, or lease contract. In application, we can see the answer for each of these factors. When asking about the total amount of rent under the lease, the total amount of rent must not exceed the cash sales price, but not by so much that the rent payments appear to be the equivalent of principal and interest on a conditional sale. Whether the lease acquires any equity or security agreement in the property determines if it is a conditional sale or lease. Because in this case, the purchase option at the end of the lease is roughly equal to the market value of the equipment, there is no equity for the debtors. Next, when trying to answer the question of what the useful life of the leased goods is, is to determine if the equipment holds a substantial value at the end of the lease term. If the leased goods hold value, then their useful life exceeds the term of the lease, keeping it in line with lease requirements. In this case, the John Deere representative testifies that the combine and flexible platform would have sold for $79,000 brand new and would have been worth $27,650 at the end of the lease. He continues stating that the Draper platform would have sold for $10,500 new and will be worth $4,000 at the end of the lease. These facts show that the property involved in the agreement is useful past the life of the agreement. The next step of the courts is to determine the nature of the lessor's business. Essentially, what the courts are looking for is that the lessor enacts in the business of leasing often enough for it to be considered a part of the course of business. Lastly, in this case, the courts must decide the payment of taxes, insurance, and other charges typically imposed by ownership. This means that the court is looking for who paid these things. In this case, insurance is the only thing paid by the lessees, continuing to validate this as a lease agreement.
Knowing the difference between a sales agreement and a lease agreement is important in business today from a legal perspective. They give different rights and responsibilities. A sales agreement means the buyer owns the item after paying for it. This means that they take full responsibility for the item. A lease, on the other hand, means the business is borrowing or renting the item for a set time. The owner still has legal rights. If a business does not know the difference, they could be facing a legal battle. By knowing the difference between the two, businesses can avoid legal trouble, understand who is responsible for the item, and follow laws and contracts properly.